Question from Senator Sinema and the other senators for counsel for the President. The Logan Act prohibits any U.S. citizen without the authority of the United States from communicating with any foreign government with the intent to influence that government's conduct in relation to any controversy with the United States. Will the President assure the American public that private citizens will not be directed to conduct American foreign policy or national security policy unless they have been specifically and formally designated by the President and the State Department to do so?
Mr. Chief Justice, Senators, thank you for the question. Let me answer in several parts. The first is, I just want to make clear that there was no conduct of foreign policy being carried on here by a private person. The testimony was clear from Ambassador Volker, and I assume that the reference would be to Mr. Giuliani, the President's private counsel. Ambassador Volker was clear that he understood Mr. Giuliani just to be a source of information for the President and someone who knew about Ukraine and someone who spoke to the President. And in fact, it was the testimony that it was the Ukrainians, Andrei Yermak, who asked to be connected to Mr. Giuliani simply because he was someone who could provide information to the President. And Ambassador Volker testified that it was not his understanding, he did not believe, that Mr. Giuliani was carrying out sort of policy directives of the President, but rather indicating his views of what he thought would be something useful for the Ukrainians to convince the President of their anti-corruption bona fides. So just wanted to make that point. It is, of course, the President's policy is always to abide by the law, by the laws. I'm not in a position to make pledges for the President here, but the President's policy is always to abide by the laws and would continue to do so. I think it is worth pointing out that many presidents, starting with President Washington, have relied on persons who are their trusted confidants, but who are not actually employees of the government, to assist in the conduct of foreign diplomacy. President Washington relied on Gouverneur Morris to carry messages in certain circumstances, I believe, to the French. FDR had his confidant who he relied on in certain circumstances to be a go-between with foreign powers, and there are a list of others. They were mentioned in some of the testimony during the House proceedings. So I don't think that there is anything, again, as I said, it was not here, but there would not be anything improper for a president in some circumstances to rely on a personal confidant to be able to convey messages or receive messages back and forth from a foreign government that would relate to the President's conduct of foreign affairs. That's not prohibited, but within his authority under the Constitution, under Article 2.
The question from Senator Durbin to the House managers. Would you please respond to the answer that was given by President's counsel to Senator Sinema's question?
Senator, Chief Justice, in answer to that question, we heard a rather breathtaking admission by the President's lawyer. And it was said in an understated way, and so you might have missed it. But what the President's counsel said was that no foreign policy was being conducted by a private party here. That is, Rudy Giuliani was not conducting U.S. foreign policy. Rudy Giuliani was not conducting policy. That is a remarkable admission, because to the degree that they have attempted to suggest or claim or insinuate that this is a policy difference, that a concern over burden sharing or something, corruption, was a policy issue, they have now acknowledged that the person in charge of this was not conducting policy. That is a startling admission. So the investigations that Giuliani was charged with trying to get Ukraine to announce into Joe Biden, into this Russian propaganda theory, they have just admitted were not part of policy. They were not policy conducted by Mr. Giuliani. So what were they? They were, in the words of Dr. Hill, a domestic political errand not to be confused with policy. They have just undermined their entire argument, even as to mixed motives, because the man in charge of it was undergoing this domestic errand. Now, you heard a suggestion there. He was only doing this, Giuliani was only doing this because he was being asked by Andrei Yermak. That is laughable. Giuliani tried to get the meeting with Zelensky, remember? And he couldn't get in the door, and then he announced that there are enemies around President Zelensky. And then they go into that phone call on July 25th. Ukrainians try to persuade the president, you don't have enemies in Ukraine. We're only friends. And what's the president's response? I want you to talk to Rudy. That's not policy being conducted there. That's a personal political errand. They just undermined their entire argument. Now, the president's counsel also essentially argues in terms of witnesses, if their case is as strong as Mr. Schiff and Mr. Nadler and others say, then why do they need witnesses? You know, you can imagine the scene in any courtroom in America where before the trial begins, defense counsel for the defendant stands up and says, Your Honor, if the prosecution case is so strong, let them prove it without witnesses. That's essentially what's being argued here. Well, I will make an offer to opposing counsel who have said that this will stretch on indefinitely if you decide to have a single witness. Let's cabin the depositions to 1 week. In the Clinton trial, there was 1 week of depositions. And you know what the Senate did during that week? They did the business of the Senate. The Senate went back to its ordinary legislative business while the depositions were being conducted. You want the Clinton model? Let's use the Clinton model. Let's take a week. Let's take a week to have a fair trial. You can continue your business. We can get the business of the country done. Is that too much to ask in the name of fairness? That we follow the Clinton model? That we take 1 week? I mean, are we really driven by the timing of the State of the Union? Should that be our guiding principle? Can't we take 1 week to hear from these witnesses? I think we can. I think we should. I think we must.
Question from Senator Durbin is to both parties. Emails between DOD and OMB officials reveal that by August 12, the Pentagon could no longer guarantee that all of the $250 million in DOD aid to Ukraine could be spent before it expired. Deputy Secretary of Defense Norquist drafted a letter that stated that the Pentagon had, quote, repeatedly advised OMB officials that pauses beyond August 19 jeopardize the department's ability to obligate USAI funding prudently and fully, end quote. Why did the president persist in withholding the funds when DOD officials were sounding the alarm that the hold would violate the law and shortchange our ally of needed military aid? It is the turn of the White House counsel to go first.
Mr. Chief Justice, and Senator, thank you for that question. I think the thing to understand is there were a series of communications reflected, I believe, in the letter that OMB has sent to the GAO and in some of the testimony in the proceeding below that the Office of Management and Budget was encouraging DOD to take what steps it could to get everything lined up, have everything ready to obligate the funds, so everything would be able to move quickly when the pause was lifted. DOD, as the email you've mentioned suggests, was saying, we're running out of time, we're going to have difficulty doing it. But the fact was that the deadline for obligating the funds was not going to be till the end of the fiscal year. And as it turned out, as I explained earlier in response to Senator Langford's question, the funds were released on September 11th, and the vast majority of them were obligated by the end of the fiscal year. So that the procedures that had been used to try to get everything pre-planned were mostly successful. Yes, there was some funds, I believe it was $35 million, that did not get out the door by the end of the fiscal year, slightly more than in past years, but every year in fiscal year 2017, fiscal year 2018, there were funds in the Security Assistance Program that didn't make it out the door by the end of the year. And in each of those years, there was also the little fix in either the next appropriations bill or the CR to allow those funds to carry over. So the planning had been to try to ensure that when the decision was made to release the funds, it would be done by the end of the fiscal year. Not quite all of it got out the door, that's true, but there is always some that doesn't get out the door by the end of the fiscal year.
Mr. Chief Justice, members of the Senate, thank you for that question. You know, as we go further and further down this rabbit hole, I think we need to make it very clear that, you know, of the 17 witnesses that the House interviewed, nobody had an explanation. And yet, again, like last night, Mr. Philbin seems to know more than anybody else in the government, more than anyone in the Department of Defense, more than anybody in the Department of State, more than anybody in the OMB who had come forward with information about how exactly this happened. But again, here are the facts. OMB interviewed about an interagency process that they supposedly said was going on long after the interagency process had already ended. In fact, as OMB was doing those footnotes that we talked about last week, those footnotes that had never been done before, that Mr. Sandy said he had never seen in his 12 years plus of time working this process. As that was going on, DOD was asking the question about why we are doing this. They had no idea. And then when the release was finally getting ready to be finally lifted, the hold rather, OMB emailed DOD saying, listen, as we've been saying all along, under the Impoundment and Control Act, there are no problems here, and if there is a problem, it's your fault. To which DOD replied back, as you may recall, you've got to be kidding me. I'm speechless, because they did not know. Nobody had told them anything. None of the other 17 witnesses knew about it. So I do want to address, before I finish, one other point. This idea that delay didn't matter. Listen, it doesn't matter if it was a 4-day delay, a 40-day delay, or a 400-day delay. Every delay in combat matters. Every delay in combat matters. And I will say, they talked about delays in the past. Well, in past years, there was about 3 to 6% of the funds unobligated because of unforeseen and legitimate reasons following the policy process. In 2019, 14% of the funds went unobligated for foreseeable and unavoidable reasons, because the president could have held them. And to this day, $16 million
Your time has
unspent.
expired. Question from Senator Johnson and the other senators for both parties. Recent reporting described 2 NSC staff holdovers from the Obama administration attending an all-hands meeting of NSC staff held about 2 weeks into the Trump administration and talking loudly enough to be overheard, saying, we need to do everything we can to take out the president. On July 26, 2019, the House Intelligence Committee hired one of those individuals, Sean Misko. The report further describes relationships between Misko, Lieutenant Colonel Vindman, and an individual alleged as the whistleblower. Why did your committee hire Sean Misko the day after the phone call between President Trump and Zelensky, and what role has he played throughout your committee's investigation? The House will begin.
First of all, there have been a lot of attacks on my staff. And as I said when this issue came up earlier, I'm appalled at some of the smearing of the professional people that work for the Intelligence Committee. Now, this question refers to allegations in a newspaper article which are circulating smears on my staff and asked me to respond to those smears. And I will not dignify those smears on my staff by giving them any credence whatsoever, nor will I share any information that I believe could or could not lead to the identification of the whistleblower. I want to be very clear about something. Members of this body used to care about the protection of whistleblower identities. They didn't used to gratuitously attack members of committee staff, but now they do. Now they do. Now they'll take an unsubstantiated press article and use it to smear my staff. I think that's disgraceful. I think it's disgraceful. You know, whistleblowers are a unique and vital resource for the intelligence community. And why? Because unlike other whistleblowers who can go public with their information, whistleblowers in the intelligence community cannot, because it deals with classified information. They must come to a committee. They must talk to the staff of that committee or to the Inspector General. That is what they're supposed to do. Our system relies upon it. And when you jeopardize a whistleblower by trying to out them this way, then you are threatening not just this whistleblower, but the entire system. Now, the president would like that, nothing better than that. And I'm sure the president is applauding this question because he wants his pound of flesh. And he wants to punish anyone that has the courage to stand up to him. Well, I can't tell you who the whistleblower is because I don't know, but I can tell you who the whistleblower should be. It should be every one of us. Every one of us should be willing to blow the whistle on presidential misconduct. If it weren't for this whistleblower, we wouldn't know about this misconduct. And that might be just as well for this president, but it would not be good for this country. And I worry that future people that see wrongdoing are going to watch how this person has been treated, the threats against this person's life, and they're going to say, why stick my neck out? Is my name going to be dragged through the mud? Will people join our staff if they know that their names are going to be dragged through the mud?
Thank you, Mr. Manager.
There's 2 responses that I'd like to get to. One, with regard to the issue of witnesses, in this case, the whistleblower. Mr. Schiff put the whistleblower issue front and center with his own words during the course of their investigation. He talked about the whistleblower testifying. Retribution is what is prohibited under the statute against a whistleblower. That's what a whistleblower statute protects, that there's no retribution. In other words, They're not going to be fired for blowing the whistle. But this idea that there's complete anonymity, and I'm not saying that we should disclose the individual's name and you handle that in executive session or any way you'd want, but we can't just say it's not a relevant inquiry to know who on the staff that conducted the primary investigation here was in communication with that whistleblower, especially after Mr. Schiff denied that he or his staff initially had even had any conversations with the whistleblower. It goes back to the whole witness issue, and I want to go to that for just 30 seconds here. It seems to me that the discussion for witnesses, I heard what Mr. Schiff said about the 30, we'll do depositions in a week. Democratic leader said I could have any witnesses I want yesterday. I've got it in the transcript. And you couldn't get all the witnesses you'd want in a week. You couldn't get the discovery done in a week. But if in fact they believe that they presented this overwhelming case that they have, they talk about subterfuge and smoke screens. The smokescreen here is that they used 13 of their 17 witnesses to try to prove their case, and we were able to use those very witnesses to undercut that case. So I think we just have to keep that in perspective.
Question from Senator Collins and the other senators for both parties. Are there legitimate circumstances under which a president could request a foreign country to investigate a U.S. citizen, including a political rival, who is not under investigation by the U.S. government? If so, what are they and how do they apply to the present case? The House goes first.
Mr. Chief Justice, Senator, it would be hard for me to contemplate circumstances where that would be appropriate, where it would be appropriate for the President of the United States to seek a political investigation of an opponent. One of the, I think, most important post-Watergate reforms was to divorce decisions about specific cases, specific prosecutions, from the White House to the Justice Department, to build a wall. One of the many norms that has broken down under this presidency is that wall has been obliterated, where the president has affirmatively and aggressively sought to investigate his rivals. I cannot conceive of circumstances where that is appropriate. It may be appropriate for the Justice Department, acting independently and in good faith, to initiate investigation. There's a process for doing that. We heard testimony about that. You can make requests under the Mutual Legal Assistance Treaty, the MLAT process, when a foreign country has evidence involving a criminal case involving a U.S. person. There is a legitimate way to do that. That didn't happen here. In fact, when Bill Barr's name was first revealed, when that transcript was brought to light, the Justice Department immediately said, we have nothing to do with this. We have nothing to do with this. Here, this particular domestic political errand was being done by the president's personal lawyer. I wanted to just follow up also, while I can, Senator, on my colleague's comments in terms of mixed motives. If you conclude the president acted with mixed motives, some of them corrupt and forbidden, some of them legitimate, you should vote to convict. That principle is deeply rooted in our legal tradition. It is commonplace in civil and criminal law going back centuries. For example, in describing the standard for corrupt motive for obstruction, the Seventh Circuit rejected any requirement that a defendant's only or even main purpose was to obstruct the due administration of justice. Instead, the court explained, a defendant is guilty if his motives included any corrupt, forbidden goals. That case, the United States v. Quito, which I cited earlier, is not only relevant here, but that case was argued by Professor Dershowitz, and he lost. He made the argument he's made and the president's lawyers have made today. They lost that case, and for a good reason. It's contrary to the history of our legal traditions. If someone, and this is the founders were concerned, for example, that a president might be charged with bribing members of the Electoral College.
I'd like to start by pointing out that the question sort of assumes that there is a request for an investigation in a foreign country of a United States person. I'd just like to bring it back, though, here to the transcript of the July 25th call, where President Trump didn't ask President Zelensky specifically for an investigation or an investigation into Vice President Biden or his son Hunter. I mean, there's a lot of loose talk in sort of shorthand reference to it that way. But what he refers to is the incident in which the prosecutor was fired. And the first thing that he says in that whole exchange is talking about the prosecutor being fired. And he says it sounds horrible to him. And the situation with Burisma. And so, and all that the president says is, so if you can look into it, it sounds horrible. It sounds like a bad situation. That's not calling for an investigation necessarily into Vice President Biden or his son, but the situation in which the prosecutor had been fired, which affected anti-corruption efforts in the Ukraine. And President Zelensky responded by saying The issue of the investigation of the case is actually the issue of making sure to restore the honesty. So we will take care of that. And he's explaining that he understands that it's an issue that has to do with, was an investigation over there, that their prosecutor was handling, derailed in a way that affected their anti-corruption efforts, and it's something worth looking into. It's the president making clear that we're not saying that's off limits. It sounds bad to the U.S. as well. But let me get more specifically to the question, is there any situation where it might be legitimate to ask for an investigation overseas? Yes, if there was a conduct by a U.S. person overseas that potentially violated the law of that country, but didn't violate the law of this country, but there was a national interest in having some information about that and understanding what went on, then it would be perfectly legitimate to suggest this is something worth looking into. We have an interest in knowing about this, even if it's not something that would mean a criminal investigation here in the United States. And so that could arise in various circumstances where a person had done something overseas, but there was a national interest in understanding what they had done.
The question from Senators Peters and Cornyn for both parties: how would the verdict in this trial alter the balance of power between the executive and legislative branches in the future? The President's counsel goes first.
A verdict, a final judgment of acquittal, would be the best thing for our country and would send a great message that will actually help in our separation of powers. Here's why. As I've said repeatedly, and according to the standard articulated so well during the Clinton impeachment, what are we dealing with here? We're dealing with a purely partisan impeachment with bipartisan opposition, no crime, no violation of law in an election year. Okay? Never happened before. No investigation, no due process, nothing. And what they're telling you, I mean, we can talk all we want, and we will, but what are we talking about at the end of the day? We're talking about removing a president of the United States from a ballot in an election that's occurring in months. Who thinks that's a good idea? Particularly when you're dealing with a purely partisan impeachment that was warned about from the framers, okay? So the only appropriate result that won't damage our country horribly, maybe forever, but certainly for generations, is a verdict of acquittal. Here's the other point, getting back to the question of witnesses. Mr. Schiff's up here. Let's make a deal. How about we have the Chief Justice, and we have the greatest respect for the Chief Justice. Here's the problem. We're talking about critical constitutional rights that have been protected by the Supreme Court for our history. So what is he really saying? He's saying that the Senate, think about these questions, the Senate can decide about executive privilege by a vote, by a majority vote. If the Senate can decide, with the greatest respect, if the Senate can just decide there's no executive privilege, guess what? You're destroying executive privilege. Can the Senate decide the House's speech or debate protection? I mean, when we ask for documents from Mr. Schiff and his staff, and he says speech or debate, are you going to decide that? Is that how we're going to do this? Are we going to flip a coin? Is that going to be your next suggestion? We're talking about an election of the president. There are critical constitutional issues that will alter our balance of power for generations if we go down that road. Down this road is the path provided by the Democrats so wisely during the Clinton administration and an election.
It may be different in the court than it is in this chamber and in the House, but when anybody begins the sentence with the phrase, "I have the greatest respect for," you have to look out for what follows. We trust the justice will make the right decision. The justice has, I think, conducted these proceedings in an eminently fair way. There is nothing in the Constitution that would preclude us from taking a week to hear from witnesses and allowing the Chief Justice to make those calls. And I would say also with respect to an argument counsel made about the Porteous impeachment trial, where yes, the Senate designated 12 senators to hear the witness testimony. The implication is you can't do that in an impeachment of the president. That's only half correct. The other half is you could do depositions in which only a couple members of the body need participate. And so it's a false argument to say or suggest that the whole body would need to conduct the whole of the depositions. So much as we would like live testimony, we've offered a compromise. But with respect to the question about what will this do to the balance of power, I would say this. As I mentioned earlier, our relationship with Ukraine will survive this debacle. But if we hold that a president can defy all subpoenas, can tie up the Congress endlessly with bad faith claims of privilege, claiming here one thing, claiming in court something else, it will eviscerate our oversight power. If the president is allowed to decide which subpoenas they will deign to consider valid and which they will deign to consider invalid, your oversight power, our oversight power, is gone. That is an irrevocable change to the balance of power. And what's more, if we adopt their theory of the case, that a president can abuse his power, can do so by holding another country hostage, by withholding congressionally appropriated funds, can violate the law in doing so, as long as they think it's in their interest. Imagine what that will do to the balance of power. Article 2 will really mean what the president says it means, which is he can do whatever he wants. So yes, the stakes are big here. Article 2 goes to whether our oversight power, particularly in a case of investigating the president's own wrongdoing, continues to have any weight, whether the impeachment power itself is now a nullity.
Question from Senator Reid and the other senators is for both parties, beginning with the House managers. It has been reported that President Trump does not pay Rudy Giuliani, his personal attorney, for his services. Can you explain who has paid for Rudy Giuliani's legal fees, international travel, and other expenses in his capacity as President Trump's attorney and representative?
The short answer to the question is, I don't know who's paying Rudy Giuliani's fees. And if he is not being paid by the president to conduct this domestic political errand for which he has devoted so much time, if other clients are paying and subsidizing his work in that respect, it raises profound questions, questions that we can't answer at this point. But there are some answers that we do know. As he has acknowledged, he's not there doing foreign policy. So when counsel for the president says this is a policy dispute, you can't impeach a president over policy, what Rudy Giuliani was engaged in by his own admission has nothing to do with policy. It has nothing to do with policy. And let me mention one other thing about this scheme that Giuliani was orchestrating and the consequence of the argument that they would make that its quid pro quos are just fine. Let's say Rudy Giuliani does another errand for the president, this time an errand in China. And he says to the Chinese, we will give you a favorable deal with respect to Chinese farmers as opposed to American farmers. We will betray the American farmer in the trade deal, but here's what we want. The quid pro quo is, we want you to do an investigation of the Bidens. You know the one the president's been calling for. They would say that's okay. They would say that's a quid pro quo to help his reelection. He can betray the American farmer. That's okay. That's their argument. Where does that argument lead us? That's exactly the kind of domestic, corrupt political errand that Rudy Giuliani was doing gratis, without payment, at least not payment apparently from the president. So who's paying the freight for it? Well, I don't know who's directly paying the freight for it, but I can tell you the whole country is paying the freight for it. Because there are leaders around the world who are watching this and they're saying the American presidency is open for business. This president wants our help, and if we help him, he will be grateful. He will be grateful. Is that the kind of message we want to send to the rest of the world? That's the result of normalizing lawlessness of the kind that Rudy Giuliani was engaged in.
Thank you. I'm sorry, your time has expired. Counsel?
Came out of the manager's mouth. Open for business. I'll tell you who was open for business. You know who was open for business? When the Vice President of the United States, who was charged by the then President of the United States with developing policies to avoid and assist in removing corruption from Ukraine, and his son was on the board of a company that was under investigation for Ukraine, and you're concerned about what Rudy Giuliani, the president's lawyer, was doing when he was over trying to determine what was going on in Ukraine? And by the way, it's a little bit interesting to me, and my colleague, the Deputy White House Counsel, referred to this. It's a little bit ironic to me that you're going to be questioning conversations with foreign governments about investigations when three members of the Senate, Senator Menendez, Senator Leahy, and Senator Durbin, sent a letter that read something quickly like this. They wrote the letter to the Prosecutor General of Ukraine. They said they're advocates, talking about the congressman, they're strong advocates for robust and close relationship with Ukraine, and we believe that our cooperation should extend to such legal matters regardless of politics, and their concern was ongoing investigations and whether the Mueller team was getting appropriate responses from Ukraine regarding investigations of what? the President of the United States. And you're asking about whether foreign investigations are appropriate? I think it answers itself.